So I don't
Wait,
really
wait, wait,
care.
wait, 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 wait. Okay.
Are we
This will confuse people. You are. Maurice?
I'm sorry, Miss Faith.
Hi, Xavier. Are you running the show today?
Yes, yes.
Okay. I am coming to you from the conference room of the BZA office. So I just want to make sure my sound quality is okay.
Okay, yeah, I can hear you good.
Awesome. Thank you.
Morning, this is Member Brown. Maurice and Liz.
Good morning. This is Xavier. I'm going to be representing city planning today. I'm
Thank you.
also
Good morning to both of you. For some reason, I'm having problems with my camera. I can't flip it. It's upside down. So I'm going to stay off screen, but I'm here and I can see you and your screen.
great.
I'll try and fix it while I'm sitting here, but I'm having no luck.
Okay, Liz, it's 9:30. We can get started.
Thank you. Good morning. My name is Liz Kukla. I'm the Secretary of the Board of Zoning Appeals. And I'm going to read the preamble for you this morning, this February 27th, 2023. In compliance with notification requirements of the city's open meeting law in section 101.021 of the codified ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the City Planning Department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting have the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Please note that call-in users can unmute by using *6. All meeting activity is being recorded via the WebEx platform. These proceedings are also being live streamed via YouTube for public view. We have provided a link to the meeting for those who wish to speak on a particular case via our website and email. All requests to speak on a particular matter have been considered. We have also received emails from those who have provided written comment on a particular matter. Back to you, Madam Chair.
Thank you. Go ahead and call the roll, please.
Ms. Roca is not present today. Ms. Holzer,
Present.
Ms. Brown,
Present.
Ms. Bay,
Present and coming to you from the boardroom of the BZA office.
and Ms. Britt.
Here.
Madam Chair, we have a quorum with 4.
Thank you. So I will announce that we only have 4 members, and we will for probably the next 3 weeks. So anyone who would want to have 5 members, a full complement, can ask to postpone their case when their case is called. Okay, go ahead, Liz.
Thank you, Madam Chair. We do have one postponement this morning. That is Truson Avenue. This will be the second postponement. And again, so this is in front of you on the screen, but I'll go ahead and read. It is for calendar number 22-220 regarding 6100 Truson Avenue. Mad Prop LLC proposes to install 513 linear feet of 10-foot high electrified security fence. This applicant is needing more time so that they can meet with a council person in the Slavic Village. I guess they've had some issues connecting. So the next available date would be March 27th, if that's all right with you. We might be able to squeeze them on the 20th if you wanted them to be heard quicker.
No, the 27th is fine. I'm a little
Thank you.
dismayed that all this is taking so long for a fence, but okay.
Thank you, Madam Chair. So calendar number 22-220, it will not be heard this morning. And if you received a letter in the mail, a paper copy of the letter in the mail, you will receive another one closer to the next hearing date on March 27th. I believe that's all that we have for postponements and withdrawals this morning, Madam Chair.
Thank you, Ms. Kukla. All right, Xavier, do we have any council people on?
Not that I can see right now.
All right, well, we can go with the first case then.
All right, our first case, good morning, everyone. Our first case is calendar number 23-011. This is for Crittenden Court Joint Venture LLC. They are appealing the decision of the Commissioner of Assessments and Licenses. Crittenden Court Joint Venture LLC, doing business as Crittenden Court Garage, appeals under the authority of Section 76-6B of the Charter of the City of Cleveland and Section 329.02D of the Cleveland Codified Ordinances from the decision of the Commissioner of Assessments and Licenses to not waive the regressive reassessment of parking tax for area residents. With that, I will hand it over to Ms. Brown for the oath.
Thank you. Good morning. I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply, I do. State your name and your address, please.
Audrey Mecklenburg, 1382 West 9th Street, Cleveland.
I do, Tom Parrish, 1302 West 9th Street, Cleveland. I do, David Bowen, 10924 Lake Avenue, Cleveland, Ohio.
I do, Bernard Butler, 601 Lakeside Avenue, room 122, Cleveland, Ohio, 44114.
Anyone else?
You should probably.
Was someone else about to speak?
And I do, Dedrick Stevens, Commissioner of Assessments and Licenses, 601 Lakeside, room 122.
Thank you, Commissioner. Madam Chair.
Thank you. Legal standard, please.
Madam Chair, members of the board, appellant is appealing an administrative decision of the Commissioner of Assessments and Licenses. The standard of review to be applied is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. If the appellant fails to meet this burden, the administrative decision must be affirmed.
Thank you. Okay, who will be the spokesperson for this case?
What was the question?
Who's the spokesperson? Who's the appellant?
Oh, I'm going to speak first, and then probably Tommy and then David.
Okay, well, before you speak, for everyone, announce who you are so we'll know for the record who said what. So who just said I'll be speaking?
Audrey Mecklenburg.
All right, go ahead, Audrey. Thank you.
Crittenden Garage was built in the late 1980s. So we were around when the parking tax was enacted in 1995. There's a lot of confusion about the parking tax ordinance at the beginning. And I personally had many conversations with the tax department in those early years. Those were the days of actually calling on the landline. So there's little documentation on this issue, but I can only address the ways things have been done over the past 27 years up until this issue arose last year. I'm going to use the word city to mean the Department of Finance, Division of Assessments and Licenses. Today, the heart of the matter is the difference between the interpretation of some of the language in the ordinance regarding who gets the parking tax exemption and who doesn't. The line of the ordinance in question reads that a resident is exempt if they park on site or an off-site facility under contract to provide parking for residents at that place of residence. The city is now interpreting this to mean that we are required to have a third-party written contract that is with a neighboring property owner. However, my question is, why would we need a third-party contract? What's the purpose of a contract to provide parking with a separate entity? It certainly can't be to restrict free parking or free trade or legal commerce within the city, can it? The city has not offered any other explanation other than that's how it's written and we're required to go by the law. With this new interpretation, the city is going back 3 years and regressively reassessing our income. When we first started, we may have only needed one such contract, but as the downtown apartments have taken over office buildings, we would now need 20 times that amount to fulfill this obligation. The ordinance does not say that a contract needs to be with the property owners. It also doesn't say written. These are inferences made by the city tax department, which we believe are biased in their favor. Over the years, we've had some contracts for parking that have been required by lenders to ensure the availability of parking, but otherwise no restrictions on rates or other considerations that would normally be considered in a contract. We can probably all agree that this line of the ordinance is not written as clearly as it should have been. There's an entire section of chapter 196, which is the parking facility tax ordinance, that is just definitions, none of which clarify or justify the city's interpretation. Without knowing the genesis of the parking tax ordinance, I can kind of see the city's interpretation, but that isn't how those in the parking world read it. Let me give you another interpretation, the one that was specifically explained by Ms. Julia Weaver, the parking tax auditor before Mr. Butler. The words under contract. In the parking world, there are two basic kinds of parkers: those that pay daily, transient parkers, and those that pay monthly, contract parker. The ordinance requires that in order to be exempt, the residents must be a resident for more than 30 days. Thus, they are considered contract parking and not transient parking. We do have monthly contracts with all of our residential parkers. In addition, parkers wanting the residential rate must certify on a form provided by the city that they are in fact residents. In the ordinance, it says at that place of residence. It is to distinguish between commuters and residents. Let me give you the example Julia Weaver gave me. A person who is a resident that lived in the city of Cleveland, say near West Side or University Circle, but drove downtown to work in the Western Reserve Building, would not be exempt. Because even though they were a city resident, when they parked at the Crittenden, they were not parking at their home. They were parking for their place of employment. For the past 27 years, this has been how the ordinance has been enforced. Monthly parker, under contract, parking where they lived, place of residence. Julie and I have had many discussions over the years regarding who and who do not qualify for the tax exemption. For instance, I had a resident who moved from Crittenden Apartments to live on East 4th Street. She asked me, well, are they parking for their residence or for their work? I said, really neither, because they weren't within a reasonable walking distance. So we decided that that was not at their place of residence. So this was the test. Are they parking for their place of employment or are they parking for their residence? She also commented that a place of residence should be within reasonable walking distance. But she never once mentioned needing a third-party contract with a landlord or owner of a building to comply with that ordinance, either in our neighborhood or any other neighborhood. We are not the only operator that operates in this manner. All operators that work downtown are operating under the same premise as us. And except for a few contracts as required by lenders, or maybe even more recently drafted because of this issue, the city has acknowledged that they are not aware of any such contracts, but that they've only now started just looking for them. I've spoken with all the property managers in the warehouse district, and none of them have any kind of contract they are now requesting. The city is now requesting. In fact, they do not want to be any way involved in a contract which may open them up to unwanted liabilities. They actually encourage their residents to shop around. At this end, I do have some exhibits I gave to Elizabeth Kukla. I'm not sure if she forwarded them, but I could also forward it to everybody here. But one of the letters is a letter from Downtown Cleveland Alliance, and they have been talking with all the stakeholders and parking lot operators in the area and have agreed that this issue is not just solely Crittenden's problem. In the spirit and intent of the ordinance, as we understood it, was to exclude the people who parked near where they lived. Downtown Cleveland Alliance said in their letter that it has been a key incentive to attracting residents and helping downtown buildings compete with their suburban competition. We have not gained any advantage by not charging said tax and not remitting it. We say if we charged it, we gave it to the city. In fact, it would be easier for us not just to charge everyone. Keeping track of and auditing those who qualify and don't qualify is sometimes overwhelming. We do the extra steps. We get residents to sign the exemption form where they certify that they are in fact residents. Most of the times it's obvious, but if there's any question, we ask to look at their leases. Many times we talk to the property managers to verify their residency. We also give residents a different means of accessing the garage to make it easier to audit. All of this is a lot of work, but we believe it is in the right thing and the best thing for building residency in the city of Cleveland. We believe it would be an overwhelming burden to further keep track of what buildings we do or do not have contracts with. When the ordinance was first written, there were just a few buildings. Now there are many buildings. How many times does a third-party contract need to be updated? Annually, change of ownership, change of parking rates, change of property managers, different members of the LLC. You'd be surprised at how often residents move between buildings, change their roommates, their credit cards, their vehicles, their license plates, and to track where they're living at any given time is a lot of work. The city finance department bears, and we believe bears some responsibility in this issue. They need to be clear, proactive, and prescriptive. They need to help us comply. Prior to last summer, they never once mentioned a third-party contract requirement. Since 1995, they cashed all our checks without any mention of a third-party contract requirement. The rules and regulations published by the department do not mention any third-party contract. At the meeting with Mr. Butler last summer, he mentioned that he would expect to see some standard contract. And I've asked several times for a sample of what they're looking for, and they have not provided it. If they're looking for some standard contract, then they should provide what standard form they're looking for. The reality is there's no reason to have a contract with a third party in a free and open marketplace. We are not poaching parkers from anyone. We have a tacit understandings with all of our neighbors to provide parking, most of which are unwritten, but I do have some letters that I would like to share with you at the end. And most of our business comes from referrals by the property managers in the area, where many times they give a prospective resident a list of parking lots in the area with our name on it. We do attract a lot of residential parkers because we are the only parking lot to operate 24/7, 365 with security patrols and security cameras. In the commissioner's letter that we received December 5th, just prior to this meeting, he agrees that we have acted in good faith and have attempted to abide by the ordinance and that we did not receive any financial benefit. We do understand that no one likes to pay more taxes. And actually, we really know that no one really likes to pay for parking either. But we are willing to pay our share of taxes. But it's not fair or even handed to go back 3 years and regressively reassess our income when the precedent has long been set. And we have we've had no indication, no warning, no letters, no notices, no nothing saying that we were doing anything incorrectly, or to say that the city is now going to interpret the ordinance differently than the way it was explained to us in the past. We believe we have met both the spirit and intent of the ordinance, as well as the letter of the law, by having contracts with our parkers for parking at their place of residence. If the city wishes to tax people that live across the street or literally across the driveway from us, then the ordinance needs to be updated and clarified going forward. I do have some exhibits. One is from the Downtown Cleveland Alliance. Tommy might want to read it. I have letters from the city tax department from 2015, the last time they cracked down on.
Ms. Mecklenburg, are these the letters you submitted to Ms. Kukla?
Yes.
Okay, so we have them on the screen. We will stipulate for the record that we have those letters. So if you want to summarize what they say, but you don't need to read the whole thing.
I won't. Yeah, there's one from the city of Downtown Cleveland Alliance, restating a lot of what I said, but they're acting on behalf of everybody in the district. Then basically they're saying it's not just our problem, it's citywide issue. There's a letter from the city tax department from 2015 saying that licenses would not be renewed for those not in compliance. It was a crackdown, and they're basically saying there's no mention of a third-party contract requirement. I submitted 3 iterations of the rules and regulations that were circulated in 1995, nowhere mentioning a third-party contract requirement. If they were thinking that this was an important part of the law at that time, wouldn't you think they would have addressed it at that time? The letter from the landmark companies, they're addressing that we've had a relationship for decades, and they're probably close to 90% of our business outside of Crittenden Court Apartments. There's also various emails from area property managers. I only submitted a few samples. And then I also submitted a form from a resident that owns a condo. Basically, if the city says I have to have a contract with the owner, am I supposed to have a contract with the owner of a condo to have a contract for parking? I mean, it's confusing, I think. These were all lumped in with the city's tax assessment. I think that concludes my presentation at this time. If there's any questions.
Great, thank you. So is there anyone else from your team that needs to speak?
Yes, David, do you want to speak?
Oh, go ahead.
Good morning, everyone. My name is Tom Paris. Everyone can see me okay, I guess. So basically, going back to cover the history again briefly, we opened the garage, I think, in with fall of 1991, give or take, prior to the, I guess, the construction of the new stadium, which the parking tax is born out of. And so to give you a little perspective historically to date, per your request for the
Mr. Burris, is there,
yes.
just talk about what Ms. Mecklenburg has not touched on.
Yeah,
so we don't need a full historic layout. So just hit
well,
the points that she didn't. That she didn't give us.
Right. No, that's what I'm doing. Yeah.
Okay.
So basically, the from the inception of our existence, beginning in 1995, which is when the tax came into place. Again, just for your benefit, we have paid you to date in tax to the tune of about $1.4 million. I think what I would say is that we have always worked very hard to be in compliance with everything that you've asked for. And over time, it has been a bit of a moving target. The residential exemption tax form didn't come on initially. That came later. And then when it did, based on Audrey's numerous conversations, our understanding was pretty clear that we had to have proof that a resident lived downtown, which we provided to you. And so what's important for you to understand, I think, is that we do not benefit one way or another from providing a discount to a potential parker or not. Our demand has been at points in excess of our supply. And so basically, we function as a conduit, correct? So if you want us to tax everyone, we'll tax everyone. And you have seen, as I mentioned, the $1.4 million in tax you've received so far has come from us to you, again, passed through from the parkers. We, offered this residential parking tax exemption because it's something you created. The letter that has been generated by the Downtown Cleveland Alliance, and I'll just mention a couple of things. I don't know if anyone's had time to read it or not. Basically says that in DCA's opinion, and I'll just kind of jump around a little bit, the ordinance lacks a clear definition of contract, as it does not specify whether a valid contract may be orally written, state of, and so on and so forth. Number two, the ordinance does not identify the interested parties required to enter into a contract, merely requires the existence of one. So that's one of the keys here. If you take a second to look at the residential parking tax exemption application, nowhere on here is there a place for property owner. There is a place for parking lot, which would be us, and there's a place for resident. So this is the parking tax application that you have used as a template that we have followed to the letter for the last many years. And it is very confusing to us now after following your direction all this time that someone should come around and tell us that, no, you interpreted this incorrectly. To be honest with you, Mr. Krupa came in our office. We provided all access to information. We had conversations with Mr. Butler, Mr. Steffens, all trying to work together on this to, I think, find a resolution that is fair and to move forward. Because as Audrey said, this does not just involve us. It involves not only even the warehouse district, but all of downtown, where someone might, qualify for some sort of exemption. So this obviously is a much bigger issue. But the point is, there is nothing in the application that mentions anything about a property owner. And to be honest with you, I think this is something with your guidance, as we have requested, if there's going to be a change moving forward, we're happy to comply. But we are looking to for guidance to provide us with a form that kind of speaks to what you're looking for. This does not. And DCA continues to mention in their letter farther down, the ordinance language requires a complete valid exemption certificate, which was under the previous administration was identified as a residential parking tax exemption form. And then they go on to say that the certificate is currently unavailable on the city website and instructions for filing are not publicly available. DCA made attempts to contact the city to acquire a copy of the certificate and were unable to assist. So, the big picture here is we have done, worked in good faith. That actually was mentioned in the commissioner's decision. All of the evidence, I'll quote, and information in this case indicates Crittenden operated in good faith and attempt to abide by the ordinance. It does not appear that Crittenden received a financial benefit from classifying the patrons in question as residential and so on. So basically, we are here again to follow the law like we've done. And the question now, it seems that the law or the interpretation to us is ambiguous. And to be honest with you, not only with DCA, but with probably half a dozen attorneys and other people in downtown area that have had a long time experience in matters relevant to this are all equally confused by this new interpretation. And lastly, what I will say is, as we provided the residential parking tax exemption application for each parker and made them available to you, historically, we were told not to present them to you, but only to keep them in a file. And I guess I'll conclude with the fact that, the finding or the interpretation, the new interpretation of what the residential parking tax exemption application should be defined as, really, I don't think was derived out of an accounting audit by Mr. Krupa. This is simply a legal interpretation where you all could have picked up this form at any time and said, well, wait a minute, we don't see the property owner on this form. Okay, so again, this has been in play now for many, many, many years. And this is why we're here today. We're continuing to pay our tax. We pay about $4,000 to $5,000 a month. We're continuing to do that. We are waiting for the new instructions. Mr. Krupa responded to Audrey to tell her that he had some suggestions, but he said they should wait until the appeal has been completed. So thank you very much all for your time. That's my statement. Thank you.
Thank you.
I just had one little quick I didn't see the letters from the DCA and stuff on the screen, but you did get them?
They were in your packet with all the rest of this. We did get it. Yes.
I just emailed it to her this morning.
No, so they won't have the, sorry, Madam Chair, to the appellant. It was too late for us to make it part of the PowerPoint this morning. So we
The
do have
DCA
the-
letter. It was the
Pardon me?
DCA letter. We think, okay.
Yeah.
But you will get that or no?
Yeah, we have it now. If you got it to Ms. Kukla, we have it.
Okay.
Presentation.
I just want to make sure.
Yeah, and Mr. Burris did summarize it, so we are aware of their position, so thank you. Is there anyone else on your team that needs to speak?
No.
All right, I'll switch it over to the city now. So who would like to speak on behalf of the city?
Bernard Butler will be speaking on behalf of the city.
All right, Mr. Butler, go ahead.
All right, good morning. All
Good
right, so just as a background to put this in context, the matter that's before the board today is not the product of a new interpretation of the law. It's a product of the assessments and licenses now having a compliance arm. In February 2021, we started conducting audits, actually sending auditors out and conducting audits. During the course of this, we've identified various issues such as hotels not reporting pet fees and different things that are subject to hotel tax, some taxpayers miscalculating the tax, and in this particular case, the residential exemption not being applied, which we believe applied correctly. The ordinance is on the screen now. If I can I'll just summarize. Basically what it states is that the exemptions for parking for the purpose of parking on site at the place of residence, basically where you live at, or at an off-site parking facility under contract to provide parking for residents at that place of residence. In other words, somebody that's under contract to provide parking for the residents at a particular place. So in other words, if it's apartment A, we'll just use an example, apartment A. You're exempt if you live at apartment A and you park there at apartment A, or apartment A has a contract with another parking facility someplace else and you park there. That is our interpretation of this ordinance. It is not a new interpretation. It's the fact that we now have auditors and are going out. We did, in order to make sure, we actually contacted the law department. The law department reviewed the situation and they concur with our interpretation of a statute, that it is basically, there has to be a contract between the parking facility and the place where the residents reside at, based on that. So that is what the basis of our making our determinations, based on our interpretation of along with the concurrence of the law department. That's as far as we can go. We try not to start using arbitrary things. One of the things that was mentioned earlier about walking distance. We don't want to get into a situation where we're starting to use walking distance. I walked about 4 miles yesterday, so walking distance for me is probably a whole lot different than other people. So we don't use arbitrary. The ordinance is written a certain way that basically when you park where you live at, or you park at a parking facility that's under contract to provide parking for where you live at, that qualifies you for the exemption. As far as the other part of the ordinance that's up, it's also what's called, commonly referred to as the statute of limitations. The statute of limitations is pretty common for whether it's federal, state, or local. Basically, it reads, except as otherwise provided in this section, an assessment shall be issued within 3 years from the date the return was due or the date the return was filed. In other words, the city, the state, the IRS, anybody, it's 3 years. The statute of limitation, you can go back 3 years. So the regressive thing is you can't audit somebody for the future. You don't know what's going to take place in the future. And you can't audit somebody immediately when the return is received. So you're allowed 3 years in which to conduct audits. So when we're going out conducting audits now, we're using a 3-year period. So that is why there's going back as far as the 3 years. That's how we conduct audits. All of our audits, no matter who the taxpayer is, are for a 3-year period.
Okay, Mr. Butler, can you kind of go back and reiterate on the third-party contract thing? This is where I'm getting a little confused.
Yes, ma'am. So the ordinance was up in front of you states, for the purpose of parking on site at that place of residence or at an off-site parking facility under contract to provide parking for residents at that place of residence. It says under contract to provide parking for resident, not a resident, but residents at that place of residence. In other words, there's a contract with that place of residence to provide parking for the residents.
Okay.
So for ABC apartment, I'll just use an example. Some time ago, I lived in Columbus in an apartment. Across the street was a parking lot. I paid my parking through my landlord, but the landlord, the apartment building had a contract with the parking lot that was next door, and that is how the parking went. So in this particular case, it's basically saying this, it's a similar situation. You can park off-site, but it has to be at a place that's under contract to provide parking for residents at this place of residence.
Okay, I got it now. That last example helped out, so go ahead.
Okay. So those, basically that is the concept. I mean, we, as auditors, we try not to use our own opinions. Well, we interpret the law, we apply the law, but we also try to apply the law fairly. We have to apply the law to everybody. There's a reason that the Lady of Justice, her eyes are, there's a blindfold or something. Everybody gets, the law gets applied fairly. Whether the Downtown Alliance or anyone else submits information, we understand that, but we basically, the law has to be applied fairly and equally to everyone. And that is what we are attempting to do, to apply the law fairly and equally, but also to apply it. And I can't emphasize enough as far as this is a product of us going out and doing audits. That's what happens when you start. We started February 2021. We have over 250 taxpayers. We anticipate auditing everybody once every 3 years. But in the course of this, we are going to identify issues similar to this in the different various areas. We cover emissions tax, parking tax, hotel tax, and motor vehicle leaser tax, and there will be issues. That's a product of going out and doing audits. There's a distinct difference between someone sending a letter, doing something, and filing your parking license in an audit where you actually go out and look at books and records and look at all the exemptions and look at everything. There's no way that anyone would know where a person is, whether you have a contract or not have a contract, basically just by filing your parking tax return. I mean, that is the gist of it. I don't know if Commissioner Stevens would like to add something, but that is the gist of it from us. At the end of the day, we're following the law. The law department agrees with us, and that's as far as we can go.
Okay, so my question here is there, so you're out auditing, you find out some people aren't paying taxes correctly as they were meant to be paying. And so there's a billing process where you say like, okay, you have to pay like this $10 million by tomorrow. Is there, or do you like work out a payment plan, or like how does that kind of go with once you find out they're behind on taxes?
Well, we issue an audit report. We go out, conduct an audit, we issue an audit report. In some cases, people have paid the tax right away. There's been cases where people weren't able to pay, and so we are in the process of setting up where they can make some type of payments.
Okay. All right, thank you. Commissioner Stevens, did you want to add anything?
Yeah, through the chair, Bernard did an excellent job of saying what our position is and our interpretation of the ordinance, as well as the law department's interpretation of the audit. Before we issued the audit report, we went through great lengths to make sure that we were correct, and reaching out to our law department and making sure that our interpretation was correct. That's about all I have to add to this part of the hearing.
Okay, thank you.
And if I could add one last thing, if allowed.
Yes, go ahead.
So one thing I will say is that we have tried to work with them. One of the things we did do is recommend that we abate the interest and penalty, and recognizing the fact that there may be, this is an issue where there doesn't appear to be any kind of malicious intent or anything done intentionally, but so we have, at least as best as we can, try to reach out and try to come to an amicable resolution.
All right, thank you. Okay, is there any, Ms. Mecklenburg or Mr. Burris, do you have anything else you want to say in rebuttal to this?
Couple quick things. The reasonable walking distance issue was not the test. The test was where they park, where they work, or they park where they reside. That's the test that we use to comply with the law. The example that Mr. Butler gave regarding his landlord paying for parking is totally different from a tenant paying their own parking. A landlord that pays parking would obviously have a contract. We've had contracts in the past with landlords to provide parking or agreements. But when a third party, when Bridgeview sends us parking, when Lubrizol, when they had tenants from Lubrizol, they actually paid for their parking, and we had an agreement regarding that. But when people live at Bridgeview that are independent paying their own parking, we don't have a contract considered for that, but we have an agreement.
We have a contract with the parker.
Yes, our contract is with the parker in compliance with the law. And I think that was the only other rebuttal I had. So Mr. Butler used, and both Mr. Butler and Mr. Stevens both used their interpretation. So that leads me to believe there's more than one interpretation of this ordinance.
So, and I'm sorry, forgive me, should I refer to you as Madam Chairwoman, or how do I refer to you?
Oh, yes, that's fine. Yes.
Okay, thank you so much. All right, and then is it acceptable to kind of ask a question? In other words, I just want to make sure, because we are confused. It is a bit confusing. I want to make sure that you all are not confused. So, in other words, this, if I can ask the question of Mr. Butler, Mr. Steffens, the actual kind of violation, or the what I want to call it in this situation, is it that that we actually owe taxes, or is it the fact that we do not have an agreement that, by your definition, meets your criteria, and so because the agreement is an error, those people now are not recognized as exempt?
Sorry, I need to unmute myself. So basically, the audit identified there's audit adjustment, proposed audit adjustment. Individuals qualified as residential exemptions per the ordinance do not meet the residential exemption qualification, and as such, that is where the additional tax is coming from. If that answers your question.
It does sort of, but again, I thought the issue here, Bernard, and thank you, was that when we read the instructions, and again, this is where everyone we talk to, we're all scratching our head. City of Cleveland residents who reside in a single family home, I know you've heard this before, let me, if you don't mind, get to one point. Multiple family dwelling unit, apartment, boarding house, condominium, mobile home occupying parking space for that purpose of parking on site at the place of residence, or an off-site parking facility under contract to provide parking for residents at that place of residence. Now, and I can read the rest of it, doesn't say anything else, providing that person resides here, to me, that's kind of the key when we say parking for residents at that place of residence. We understand that. And again, if you look at the document or the form that you've given us, the place of residence is listed, right? That information, the name, their address, that's their place of residence. I think what you are telling us, in my opinion now, is that what you'd like to see is provide parking for residents with that place of residence. Now, I know it's one word, okay? But this is, and again, Madam Chairwoman, this is where I think, to be honest with you, we're a little frustrated, because we really think we are complying completely with everything that has been explained to us over the years. And this is why one of the suggestions that I made and our effort to try to work with you all moving forward, and again, to continue paying the tax, whatever that tax may be, under new definitions, whatever. But we need kind of your guidance to provide a form that speaks specifically to what you're looking for. And this is what we don't feel we have had, or based on our interpretation, we feel we've had. And again, based on that, we have continued to pay you in good faith everything that based on the definition, we have owed you. So again, for me, just to be clear, Madam Chairwoman, the confusion I think we have here is that we are providing you information above and beyond what you probably are even asking for, which is residents' names, their address, their model, make of vehicle, all these things. And it seems that the interpretation that we were handed from the forgive me, the Division of Assessment License was simply that they want to see a contract between us and the property owners. Now, you know, to me, that provides much less information, number one, and number two, it does not help you to as clearly determine the validity of someone who claims to be a downtown resident parking downtown, qualifying for the exemption. So again, we are here to follow the law, to work with you. We think we've done so, you know, up till today, and we'll continue to. And again, you know, I have to tell you, whether we had paid you 1.4 million or 1.5 million, makes no difference to us, because we're simply following what we thought was your directive to provide incentive for people who want to park downtown, or not. But again, if you read those instructions very carefully, this
Okay,
maybe
Burris.
is where the hangup is. So thank you. I'm sorry. Go ahead.
Mr. Burris, yeah. All right, so Mr. Butler, I'll let you respond to that, but this is yeah, because this is something that you all should have done before you got here. So I'll let you do this back and forth here, and then I'm not sure if you all had enough time to even do this before you appealed the decision to come here. So go ahead, Mr. Butler.
All right, so I'll make it brief. Okay, what the city's position is, and I'm not going to use real taxpayer. We'll just use, well, with the exception of you guys. So apartment A has a contract. Apartment A doesn't say, for instance, apartment A, either they have parking, don't have enough parking, so they need to have a place for their residents or tenants to park. They reach out and they make a contract with ABC, or we'll use Crittenden Court. So there's a contract between apartment A and Crittenden Court. The patrons still have to fill out the residential, but when we come out and do an audit, you have these pile of residential exemptions for 12 people. Okay, we see these 12 people there, they all reside at apartment A. Where is the contract between you and apartment A? You provide the contract between apartment A and Crittenden Court Garage, and that is it. Basically, you're within the law as we interpret it.
I'm sorry, Bernard. I hear what you're saying. I thought that's exactly what we did, though. Is we provide you a contract between ourselves and the resident that lives at whatever residential structure is in question.
No, I said a contract between apartment A. I use a random thing. Apartment A and Crittenden Court Garage.
You mean okay, like apartment entity? Okay,
Yeah.
so then forgive me.
Apartment A. I'm just making up a name. I don't want to use real taxpayers' names. I'm just saying.
Madam Chair.
Hey, hold on. You two, like we're ending this now. This is something that if Mr. Burris and Ms. Mecklenburg, if you feel like you can work this out with assessments, and you want to, you know, withdraw from this case and try to work with them on that, you can do that. Or if you can want us to move forward and make a decision, but we don't have, the Board of Zoning Appeals is not here for you to work out the case. So you can take a pause and then work out with assessment and license, or you want us to make a decision on it today, right now. But the back and forth with trying to figure out what's your best approach is not appropriate for this venue.
Okay,
No,
understood.
We want to move forward as long as you're considering all the letters and documentation that was submitted.
We do. All right, so I'll open it up to my board now because I'm sure they have a lot of questions for you. So,
Madam Chair, this is Member Brown. And as I am listening and reading some of what's very small print on the screen. It is not clear to me that a contract with an apartment, an offsite apartment versus a contract with an offsite resident is clearly described in the ordinance. Contract seems to be the word, but not very good descriptors. And a 27-year history. So I appreciate the audit and the attempt to have good oversight on the city's part. I don't understand why they don't clearly define it and go forward. So I have questions about going backwards. Maybe it's correct, as the city says, but I'm not sure of the application of it.
So is that a question to the city?
The question to the city is, in going back 3 years, because some of the people who had contracts did not pay a tax, is it fair to have the company now pay that tax that they never collected? That seems to be the place that they will be in. Is that correct?
Yes, may I respond?
Yes.
Okay, yes, so basically as the ordinance is up and it's kind of small, I do agree. But generally speaking, in audits, whether it's the federal, state, or local, it's always 3 years. You go back 3 years. There's an expectation that you are not going to be sitting at your desk when somebody files a tax return and be immediately able to audit the tax return. That's why there's a 3-year statute of limitations in order to go back. So that's where the 3 years comes from. That's where going back comes from. The challenge that we have is that when someone, if we take everybody and say, well, you didn't know or you did it wrong, then you kind of defeat the whole purpose of having audits. And then you say, well, all those other years you did it wrong, that's okay, but moving forward, don't do it right. Well, there's no incentive to do it right in the first place, because you just wait till you get audited, you file returns wrong, wait till you get audited, and then say, okay, well, that's good, and I won't do it moving forward.
No, so Madam Chair, I don't want to have the back and forth either, but he didn't answer my question. So you've done the audit and you have a new interpretation. For 27 years, they had a different one. But you're in charge now, so I give you that full authority. The question isn't about your audit, it's about what are you levying? If you're levying a tax where they didn't collect the tax, then they are disadvantaged because they operated in a manner for 27 years that others allowed them to. So you could do the audit, they could fail the audit. Are you assessing a tax where they didn't collect any?
To answer your question directly, yes, but if I could use just one example, emissions tax. You're expected to, when you pay admission to go into a place or any place in the city of Cleveland, there's an emissions tax. When we come across people who haven't collected the tax and haven't paid over the tax, it's the exact same situation. They're still required to pay the tax. It's the taxpayer's obligation to collect the tax. It's not the city's obligation to collect. It's the taxpayer's obligation to collect the tax.
Sir, I completely agree with you on that. The difference here is the interpretation of an ordinance that is not clear about contract with a third-party parking vendor versus contract with a parker, for the person who parks who comes from a different apartment. Those are the questions that I'm asking you. And so, Madam Chair, thank you. I appreciate the opportunity to raise the question.
No problem. Thank you, Ms. Brown. Any other board members?
Madam Chair, during all this testimony, I've taken a full page and a half of notes on this.
You're the only one.
Yeah, as I usually do when we have something that's a little more unusual. And I guess I have some thoughts on this. First off, before us is, the issue of the judgment by the city on this assessment of these folks. They have a 27-year history. It's a new ball game now. They started audits in 2021. We have seen with regard to, parking off-site of residents, we often are seeing these days developers coming before us because they don't have adequate parking and they need to contract off-site parking to try and mitigate their deficiency in what is required of them. So I think going forward, we're going to see more often than not parking that is not necessarily on site, that is what I'm going to call auxiliary parking, that will be, somewhere available for residents to park should they need it. So I think that's something as we move forward, from 27, 30 years ago to new circumstances today, I think we need to be agile on things. I think the fact that the appellant today is someone who has been in the parking business for 27 years at least, since they've been working with predecessors on this. So, and the audit started in 2021. So as is often the case when these sorts of cases come before us, they are often a catalyst for communication, education, a forum to get everyone on the same page with what is expected and how people need to interpret things, what is expected, how procedures and policies are going to be going forward. So it seems to me that there's a little gap in understanding, and perhaps there could have been or could be an opportunity for better communication between between the office and the city and the folks that are involved in the parking situation. Because as more developments are going on downtown, and as I said, we're seeing this more and more off-site parking, that may change the filter through which things are seen. I feel like there's been an awful lot of discussion. You have noted as well the back and forth between the parties here today. And that's really, in any case, we expect that to happen before they get before us. And it seems like there hasn't been enough discussion to hammer out details and have a full understanding. So those are kind of my comments. I think you offered the appellants the opportunity to step away today and kind of work with the city on this. They said they wanted to move forward. I don't know if maybe they want to reconsider that. But I think all parties involved, there doesn't seem to be a clear meeting of the minds on this. We can go ahead and vote. I'll make a motion, but I'll leave it to you to see if the folks want to, reassess their decision.
Yeah, the appellants can answer Ms. Faith on that.
Yes, I thank you. Again, Tom Paris. So, and not that it matters, I also property owner and been in apartment management. My father started in 1964. And we've just recently kind of exited from that arena. I've been in eviction court numerous times, going back to Magistrate Pope and many others who I had nice relationships with. And typically,
Mr. Burris, we just need to know if you want to continue with
I'm sorry,
us making a decision
forgive me.
today
Yeah,
or not.
I appreciate that. My only point was in housing court, they offer you that same opportunity, and I think it is a good one. To date, our opportunities to converse have been limited because it's simply been an appeal hearing and then a letter response. If we could have an opportunity to have some sort of dialogue, I think we'd love that, because I think we would like to try to provide maybe, forgive my, hubris here, maybe some guidance with our experience moving forward to facilitate. So I don't want to speak for everyone, but I would say I would be open to that, to see if we can't work something out with the city. And then my question to you is, if we cannot, then do we end up appearing back before you? Is that how it works?
Well, that's your decision. If you feel like you can't come to a meeting of the minds, then you can file another appeal if you want, but that will be your decision.
If Commissioner Steffens and Mr. Butler are open to this, we would be more than happy to try to continue a dialogue to try to, I would resolve this or get an understanding and move forward together. Sure.
Yeah, I'll let them speak for themselves, but it seems like, because that's why I asked the question earlier,
Sure.
if people can't, come up with the money immediately, or there's a different, assessment that happens or whatever, is there, a time that they work with the person that's being audited? And from my understanding, that is the case. But Mr. Butler, you can, or Mr. Stevens, you can chime in on that.
I would defer to Commissioner Stevens since he is my immediate supervisor, so.
Okay.
Yes, Madam Chair, we're willing to, we always offer, even prior to, we've never done a parking tax audit until 2021. However, there has been emissions tax audits, going back, through the years. And in those situations, which is the same as this situation, we work with all of our taxpayers to try and come up with something whereby it works for everyone's interest, that is fair, and to the city as well as to the taxpayer.
Okay.
Chair, thank you to the commissioner. That is good to hear. This situation is more than about the Crittenden Court parking.
It will be, definitely, yes.
Yeah, right. And so if we're going to postpone, I know it's this audit that has flagged the issue, and you are, in conversations of assessing a tax to this particular owner. But the conversation ought to be bigger, because we will encounter this as they continue to do their audits. I mean, the legislation ought to be considered. This ought to be more than a license and assessments issue.
I agree with that totally. Unfortunately, we just have to deal with this in front of us today, but I agree with that totally. That
But as the
this is gonna trigger a
side,
bigger, yep.
Yeah,
Right.
no, I'm sorry to talk over you, Madam Chair, but as
That's
the
okay.
city side meets with this owner, I mean, the idea of bringing Downtown Cleveland Alliance into it and the councilman for legislation is it's their opportunity to do that, to fix this. Because the definition of contract is ambiguous. It's their call, their law department, but how anybody else reads it is a question. So, thank you.
Thank you.
Madam Chair, if I may, to the commissioner, thank you for your statement and your openness with working with the folks. And as I had touched on previously, as is so often the case when people come before us, we have, we're moving forward. We have to be agile, moving into new situations, new housing in the city, new parking situations in this case. But it offers us an opportunity to improve how we work with the constituents and the residents of the city. So I think it's excellent, and this serves as a catalyst, and it's excellent that you're willing to work with folks and maybe reach out to other stakeholders that might have interest in this. So thank you very much for your statement on that, Commissioner.
And if I can just chime in real fast,
Yes.
Yes, we clearly understand that this is an issue that is actually bigger than Crittenden Court, and we are looking at it holistically, given the development that is going on downtown, as well as all of the, not just residential and condos, but the businesses moving in, which is going to cause, constriction of the amount of available parking. We are looking at all of that. However, for this particular issue, all of what may happen, we can't talk about at this moment.
Yeah, no, completely understandable. I think the board was just letting you guys know that this is going to be a bigger matter. And particularly for us, like we might start seeing this stuff again if something isn't worked out in between time. So
Right.
from what I'm getting here is Mr. Burris is willing to withdraw his case today and work with the city to try to come to a mutual agreement on it. Is that correct, Mr. Burris?
It is, and forgive me, just so my understanding is clear, and I only reference the housing court example because we created an opportunity there to mediate amongst the parties, but if we couldn't find, common ground agreement, then we could go back to basically where we started, which was our hearing today. So then we do have the opportunity to revise our appeal if we can't reach an accord. Is that it?
That's correct.
Okay, and that's fine. Yes, I think we're fine with that.
All right, great. So,
Great.
this case has been withdrawn without objection, board?
Without objection.
Thank
you
you
for your
everyone
time.
for your time. And then Commissioner and Mr. Butler, then feel free to reach out to us. We can try to reach out to you. I'd like to obviously try to.
Yeah, I think you should reach out to them since you need.
Very good. All
Yeah,
right, We'll
okay.
do that immediately. Thank you so much.
All right, thank you.
Thank you, everyone.
All right, next case.
Thank you.
Thank you.
Still no council people on, right?
No, yeah, I saw Councilwoman Gray on about halfway into the discussion for the previous case, but then I think she got off.
All right, well, we'll just move with the next case then.
And Madam Chair, we
Cases, actually, I think, are all these grouped together, Liz? Are they all in the same area?
So these are actually scattered sites. I
Oh,
think
okay,
there
all
are
right.
one or two that are close to each other, so we should probably take them.
We'll do them one by one. Okay, thank you.
All right.
No bundle on these, huh?
No,
Okay. All right, Nina.
We'll start off with calendar number 23-016. This is at 1546 East 65th Street. Famicos Foundation proposes to erect a 1.5-story frame single-family residence with attached garage on a City of Cleveland land bank lot. The appellant appeals for relief from the strict application of the Cleveland codified ordinances as stated in the agenda and the public record, of which there are 3. And with that, I will hand it over to Ms. Brown for the oath.
Okay, I'm swearing in those who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply, I do, state your name and your address, please.
I do. Katie Gillette, 12205 Larchmere Boulevard, Cleveland, Ohio, 44120.
Do Khalid Hawthorne, Famicos Foundation.
Carolyn Dawson, Famicos Foundation. Anyone else? Madam Chair.
thank you. History of the property, please.
Thank you, Madam Chair. There's been no change in the zonings since 1929. In our records administration, we didn't find any records. There are no variances on file. But then in the more recent history, we see that in 2002, a condemnation notice was issued for a structure on the site. And then also in 2002, a permit was issued to correct the condemnation and demolish the structure. And then after that, in 1999, we see that there were vacant lot cleanup assessments made to the property and payments were made between 1999 and 2010. That's all that I have. Thank you.
Thank you. Legal standard, please.
Madam Chair, members of the board, appellant is requesting area variances from the rear yard and side street setback requirements of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code.
Thank you. All right, who's going to be the spokesperson?
I will. This is Katie Gillette with City Architecture.
All right, Ms. Gillette, go ahead.
Okay, thank you very much, Madam Chair, and to all on the Board of Zoning Appeals. Before I get started, so these next several cases are all part of one large scattered site infill development. So I don't know if it'd be possible for me to present all of them as a whole, and then maybe we can come back and take action or discussion on separate
We
ones.
can vote. Yeah, we'll vote separately, but just let
Okay.
us know what addresses you're talking about before,
Yeah,
but then we'll read
absolutely.
each one in the record. Okay.
Perfect. So, and actually, not to get off to a rocky start, but this address for 1546 East 65th Street, we would like to pull from this agenda and postpone this particular case.
Okay.
But the rest of them are all very straightforward.
Madam Chair, would you like to give it a date?
Yep, I was just writing that down. How much time do you think you need, Ms. Gillette?
We just need to get a revised nonconformance letter from the zoning office. So we don't need a lot of time. I'm sure I can get that this week, but we are going to make an adjustment to the site plan, which is going to impact and add a variance that we will need.
Okay. What's the one before March 27th we had the list?
March 20th.
20th. Okay. We'll put you on for that.
Okay, that sounds good. Thank you.
And we'll need to get that notice of nonconformance as soon as you have it so that we can make sure that the notice that goes out to the public will have the correct information.
Okay, I will make sure we get that in the next couple of days.
All right. I'm sorry. So Ms. Holzer, you have to read this one in now. Let's start over.
All right. We have calendar number 23-017. This is at 6715 Longview Avenue. Famicos Foundation proposes to erect a two-story frame single-family residence with a detached garage on a City of Cleveland land bank lot located in a B12 family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 3. And with that, I will hand it over to Ms. Brown for the oath again.
Okay, Madam Chair, may I ask if we swear in everyone who's testifying on all of these, and will we need to do it each time?
Nope. Actually, what we're going to do to avoid that is we're just going to read each case in now.
Yep.
And then we'll swear them in once, and then Ms. Gillette can take each one as they come up.
Okay. So I
Thank you,
will
Madam
read.
Chair.
All right. We have, in addition to calendar number 23-017, we have calendar number 23-018. This is at 6719 Longview Avenue. Famicos Foundation proposes to erect a two-story frame single-family residence with attached garage on a City of Cleveland land bank lot located in a B12 family residential district. I'm debating whether or not I should read all of them and then reference the code. In this case, the appellant appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 4. Next, we have calendar number 23-020. This is at 7408 Melrose Avenue. Again, Famicos Foundation proposes to erect a two-story frame single-family residence with a detached garage on a City of Cleveland land bank lot located in a B12 family residential district. The appellant appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 3 for this one. Next, we have calendar number 23-021. This is at 7412 Melrose Avenue. Again, Famicos Foundation proposes to erect a 2-story frame single-family residence with detached garage on a City of Cleveland Land Bank lot located in a B1 2-family residential district. Again, the appellant appeals for relief from the strict application of the Cleveland Codified Ordinances, as stated in the agenda and the public record, of which there are 3. We have calendar number 23-022. This is at 7416 Melrose Avenue. Famicos Foundation proposes to erect a 2-story frame single-family residence with detached garage on a City of Cleveland Land Bank lot located in a B1 2-family residential district. Again, the appellant appeals for relief from the strict application of the Cleveland Codified Ordinances, as stated in the agenda and the public record, of which there are 3. And then 2 more. Calendar number 23-019. This is at 1694 East 70th Street. Famicos Foundation proposes to erect a 2-story frame single-family residence with detached garage on a City of Cleveland Land Bank lot located in a B1 2-family residential district. The appellant appeals for relief from the strict application of the Cleveland Codified Ordinances, as stated in the agenda and the public record, of which there are 2. And our last one is calendar number 23-025. This is at 1698 East 70th Street. Again, Famicos Foundation proposes to erect an 18-foot 4-inch by 36-foot 6-inch 2-story frame single-family residence with detached garage on a Cuyahoga County Land Bank lot. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances, as stated in the agenda and the public record, of which there are 2. And with that, I will hand it, well, we're doing the oath again. So with that, I will hand it over to Ms. Brown for the oath.
And get a cup of water, Ms. Holzer. That was a lot going on there.
Thank you.
Thank you for doing that. So I am at this time swearing in all who are present for the cases that were just read in by Ms. Holzer. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand. Reply, I do. State your name and your address. And this would mean anyone from the development entity and any residents or owners of properties adjacent. Anyone who would like to speak to all of the cases that have just been read in. Thank you.
I do. Katie Gillette, City Architecture, 12205 Larchmere Boulevard.
Khalid Hawthorne, Famicos Foundation, 1325 Ansel Road.
I do, Carolyn Dawson. My apologies, my camera's not working. 1325 Ansel Road, Famicos Foundation.
Anyone else? Madam Chair.
Thank you. So we'll start with the long view. So we'll let Xavier get back to the beginning. But we'll start with the long view 23018. History of the property, please.
Thank you.
19, yeah.
Thank you, Madam Chair. And again, this is for, I do have the history for both addresses of 6715 and 6719 Longview. There's been no, there've been no change in the zoning for both of these addresses. There's not much in our records administration office on these addresses, no variances. But we did find that in the more recent history that in February of 2010, there was one structure at each address that was demolished. And that's all that I have. Thank you.
Thank you. And for legal standard, Mary, if there's any different ones, you can read those. But if there are some that are the same, you can just tell us which ones that apply to.
Okay, these are all area variances. So
okay.
They will all have the same standard. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code.
Thank you. All right, go ahead, Ms. Gillette.
All right, thank you everybody for that. I did submit a presentation, which I don't see here, but that is okay. I can speak quickly to the project as a whole. I'm working with Famicos Foundation to develop 40 in total scattered site single family homes in the Huff neighborhood, right around the League Park in particular. The 40 homes are primarily funded by the OFA Housing Finance Agency. They will be lease purchase homes, so they will be owned by Famicos for 15 years and rented by tenants, and then on the 16th year they are given the opportunity to purchase the homes. The homes themselves are all 3-bedroom, 2-bathroom homes, and we're looking forward to the the impact that they will have on this neighborhood. So the sites that are here before are the sites that do have that will be requiring variances. I do want to make mention that we are not seeking any variances for the front yard setback. That is noted on a couple of them. We have adjusted our site plans, so there's no front setback variance. We are also nearly through our city planning process and are not looking for any variances in terms of city planning approvals. Those are well on their way. So the first two sites, 6715 and 6719, sit together. They're actually part of, perfect. They're part of 3 parcels here, and you see the site on the right is not one that were here before, but is sort of triggering this variance. We are putting an accessible home on that site. The accessible homes require a 50-foot wide lot. So in order to achieve that 55-foot lot, we are replatting the 3 houses you see here in a row. So there'll be 35 feet, and then 50 feet. The zoning code itself requires a 40-foot lot, so we're below that requirement. But again, it is to achieve the buildable area needed for the accessible home on the right. So that's the gist of 6715 is on the left, 6719 is in the middle here. That one also has an additional variance for the detached garage because as the code reads, we are required to be about 14 feet from the main building on an adjacent lot. However, you'll see that detached garage is really in proximity to the attached garage of the single-story house to the right. So we feel comfortable with that relationship because it is garage to garage, and the alternatives would be really taking away additional yard space, trees to push the garage back if we have to do that. So that covers these 2 sites on Longview.
Right, so I think I'm gonna bundle these according to street. So so I will, if board, you have any questions about the Longview properties, now is the time.
I'm great with that approach, Madam Chair.
Okay. Well, I hear no questions. I'll entertain a motion for 23017 and 23018.
Thanks. I'm familiar with this area, having worked with the Urban Land Institute on a project of the new housing development that's going in by League Park that I did last year. So anyway, these are all pretty standard. As stated, there were no front yard setbacks, there are only side yard and rear yard setbacks. So we're going to do calendar number 23-017 and 23-018. Those are the 2 lots on Longview. So I move that we go ahead and approve the variances for those 2 cases.
Thank you. Can I have a second?
Madam Chair.
Ms. Brown with the second. Go ahead, call the roll.
Thank you, Madam Chair. And this is with the understanding that number 3 and number 4 will not be.
Yes.
Sorry, number 3 for 2317 and number 4 for 2318. And also for 2318, the item number 1 regarding the front yard setback is no longer being requested. We will need to see that site plan. I'm not sure if it was part of this presentation or not, but we do need that revised final site plan for our record. And then I'll go ahead and call the roll, Madam Chair. Ms. Holzer,
Yes.
Ms. Brown,
Yes.
Ms. Faith,
Yes.
Ms. Britt.
Yes.
Calendar numbers 23-017 and 23-018 are granted. We will hold ratification until we receive that revised final site plan. Once we receive that, we will ratify these cases and then we will send the appellant a letter.
All right, now we're on Melrose.
Okay, if we can go to the site plan for the Melrose sites. Perfect. Right here, we'll be building 3 two-story homes in a row, and the existing lot configurations today of these lots are not equal. So essentially the widths are from west to east, 47 feet, 34 feet, 33 feet. Those 34 and 33 foot wide lots as they exist today are not wide enough to build a house and a driveway and a garage. So what we are going to do is take those 3 parcels and replat them. They'll essentially be 3 lots each at 38 feet wide. And that 38 feet is below the 40-foot lot width that's currently required.
Okay. All right, any questions, board, on Melrose cases?
No questions. Thanks for the information, Ms. Gillette, on the replatting.
Excuse me,
sounds good.
I did want to
So,
just kind of mention, I think these also had the variance for the front yard, but I think these also were revised.
Okay, I was just thinking that, and thank you for chiming in on that, Xavier, because I forgot to ask you, because it's Xavier and not Maurice, and my brain was in a whole different place. So
That's right.
sorry. So I'm sorry for that, particularly on the last one, I should ask you. So if I don't, just say, just like yell at me and let me know. Okay.
Okay.
All right, so I'm assuming city planning is okay with these, but just for the record, Xavier, go ahead.
Yeah, considering just the change with the need for the front yard setback, and then yeah, we usually kind of always run into the issue of the minimum lot width. I mean, when new development is happening here in Cleveland. So yep. There's no real need for fireproofing the walls because of the closeness. I mean, because they all have decent side yard setbacks, so city planning recommends approval.
Right, thank you. All right, go ahead, Ms. Faith.
I think Xavier said that just for me because I'm always about the firewall and the fire
think he did.
protection. So thanks, Xavier. With regard to the Melrose properties, this is cases number 23-020, 23-021, and 23-022. I move that we go ahead and approve the variances for those 3 cases on Melrose.
Thank you. Can I have a second, please?
I second, Madam Chair, and I also just assume that the councilwoman is in support of all of these 40-unit homes in her ward.
I'm assuming so. Mr. Hawthorne?
Yes, so she's aware and supports these projects, and we've had community meetings and participated in her ward meeting as well, and have been continuously communicating this project to the community.
All right, thank you. Is there anything else you wanted to add as far as for me goes? I know Ms. Gillette's kind of speaking for you, but just in case you wanted to say something else.
No, just we're excited to get these projects moving forward. I think it's been a pretty good process, and just the the level of activity with these putting these vacant lots back to use is critical. A lot of vacant land over here, and there's a lot of potential activity as well. And we want to make sure it's a mixed income community, and so we're going to have a broad range of incomes that come in the next 5 years or so.
Okay, thank you. Ms. Dawson, anything you want to add?
No, Khalid is correct. We need to address much needed density in the areas we chose for this project. We want to align with a lot of the new development in that area, including the Cleveland Foundation, the Health Library, the expansion of Lee Park, the expansion of Dunham Museum, and the 66th Streetscape. A lot going on. It's a perfect alignment of our housing with these activities.
Okay, thank you. All right, go ahead,
So-
Ms. Faith.
Okay, well said, Miss Dawson. There is a lot going on, and it is a perfect alignment. And we haven't seen Khalid for a while, so always good to hear his input. And we know that things are there's going to be all the I's dotted and T's crossed in terms of community engagement and everything else going on. So with him on board. So thanks for your input. And with that being said, we have calendar number 23-019 and 23-025, both addresses on East 70th Street. And with that,
We're on Melrose right now, Ms. Faith.
Oh, I'm sorry. We're
That's okay.
back to Melrose. Sorry. That first case was like 4 days long. So the Melrose cases 23-0, oh, excuse me, 23-020, 23-021, 23-022. And those are the addresses on Melrose. So I move that we go ahead and approve the variances for those.
Thank you. Can I have a second, please?
Second.
Ms. Brown with the second. Go ahead, call the roll.
Madam Chair, I do have a question. If we could just have the applicant confirm that there is a revised site plan regarding those front yard setbacks.
Front yards.
Yes, there is. And I'll make sure you have those this afternoon.
Okay, thank you, Madam Chair. So for each of these cases, we are granting the first item in the description for each case regarding the lot width. So, so Madam Chair, for calendar, oh, sorry, I will go ahead and call the roll. Ms. Holter? Ms. Brown?
Yes.
Ms. Faith?
Yes.
Ms. Britt?
Yes.
Calendar numbers 23-020, 23-021, and 23-022 are granted conditionally. We will hold ratification until we receive those revised drawings, and once we receive those, we will ratify them the following Monday and send the appellant a letter.
Okay, now we're on to the 70th Street.
Now the 70th Street.
Yeah.
All right, if we can go to the site plan for this one. This is similar to the Longview sites that we looked at. We are replatting these 3 sites in order to accommodate a 50-foot wide lot for the accessible home that is on the north. And in order to do so, that is causing us to have narrower lot widths for the 2 houses on the south of the property. We're not looking for any front setback variance. Oh, that wasn't in this one. So really, that's the gist of it. Just narrowing the 2 lots to the north to accommodate the wider lot. Sorry, narrowing the 2 units to the south to accommodate a larger lot to the north.
Okay, Xavier for city planning.
Hello, this is Xavier, representing city planning. Sorry, just like the previous few projects that we just approved, there's no real concern with the minimum or the 40-foot width for the site. So considering these aren't really the closeness for concern, which I mean, and then a lot of the infill development that's happening in Cleveland now, this is kind of a hurdle that they all need to jump. But yeah, seeing no real concern, recommend approval.
Thank you. Anyone for Famicos need to add anything for these properties?
Nothing to add at this time. Thank you,
Thank you.
Madam Chair.
All right. If no questions from the board, I'll entertain a motion.
Okay, great. Great to see some ADA housing that's going in as well and accommodating aging in place. We are on East 70th Street with these two cases. So this is calendar number 23-019 and 23-025. City Planning has weighed in with their approval. So I move that we accept the variances for these two cases.
Thank you. Can I have a second, please?
Brown, I second.
Ms. Brown with the second. Go ahead, call the roll.
Thank you, Madam Chair. And just like to say one more time for the record that we are only granting item number 1 for each of these. Okay, Ms. Holzer?
Yes.
Ms. Brown?
Yes.
Ms. Bate?
Yes.
Ms. Britt?
Yes.
Calendar numbers 23-019 and 23-025 are granted. They will be ratified next week, and we will send the appellants a letter.
All right, thank you. Good luck with everything.
Take the support.
Looking
Thanks,
forward
everyone.
to seeing this come to fruition. Thank you all.
All right. Leaves the last case.
And we do have Councilman Gray on, it appears.
Okay, go ahead, Ms. Holzer.
All right, our last case is calendar number 22-232. This is at 12503 Kinsman Avenue. Davian King LLC proposes to establish use as a carry-out restaurant in a B12 family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 3. This case was postponed from January 23rd at the request of Councilmember Deborah Gray for further review. And with that, I will hand it over to Ms. Brown for the oath.
Thank
Before you
you.
hand it over, I just wanted to say I'm sorry. This is her assistant, Sierra Wilson. Hi, everybody. I didn't want you guys to think it was her. She's actually in another meeting, so I'm just standing in for her.
Okay.
Okay.
So I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand. Reply, I do. State your name and your address, please. So Sierra, are you going to testify on behalf of Councilwoman Gray?
Is that just approving it or not approving it?
Or commenting at all? Any comment?
It's just giving your perspective on, well, the councilwoman's perspective.
If you're speaking for her, you have to be sworn in.
Yeah. So what do I need to do?
Raise your hand, reply, I do. Well, you heard the oath, right?
I do, and state my address.
Your name and your address.
Okay. I do. Sierra Wilson, 601 Lakeside Avenue.
Okay, thank you. Is there anyone from the applicant here to speak on behalf of this case?
Yes, ma'am. That's Juan Hill.
You also need to be sworn in, sir.
Yes, I do. I say I do. My name is Antoine Hill. My address is 5598 Laurie Drive.
Thank you, sir.
You're welcome.
Okay, Madam Chair.
Thank you. Did we get history last time, or was it postponed before then?
I believe it was postponed before we gave the history.
Okay, go ahead.
Go ahead. Madam Chair, this property was originally zoned general retail in 1929. In 1967, it was changed to local retail business. And then in 2008, it was changed to the current two-family residential district. Madam Chair, we did find in our records administration office that in 1927, a permit was issued to erect a gas station and a canopy. In 1961, a permit was issued to erect a steel storage shed. 1968, a permit was issued for alterations to block up lube windows with masonry. And there are 2 variances on file, Madam Chair, and calendar number 79-57. This board granted a variance to to expand the use to add a repair garage at that site, and that was that year was 1979. And then in 2000, a variance was requested to erect a cell tower on the site, and that variance was denied. And Madam Chair, I believe that is all that I have that is relevant. Thank you.
Thank you. Legal standard, please.
Madam Chair, members of the board, appellant is requesting a use variance and area variances from the landscape requirements of the zoning code. To obtain the use variance, appellant must prove that denying the request will result in an unnecessary hardship particular to the property such that there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code.
Thank you. Okay, Mr. Hill, tell us what you'd like to do.
How you doing? I had, before the COVID hit, we had went through the process of what we're doing now. And I believe his name was Richard Wagati or something like that worked for the city. He zoned it commercial and then when we went back after the COVID to try to work on the property, they said it was zoned as a 2-family. So now we're here going through the process to get it zoned as a commercial, because I remember when they was going to put, I believe they was going to put apartments or something right there. So they made it residential. But I believe the business was always commercial. I didn't know. So as I purchased the property, I got with an architect and everything. We was drawing plans to make a pizza place. And then we got hit with the thing by the city saying that we need a variance and all that stuff to come back and get permission from the councilwoman and you guys.
Okay, so you want to do a pizza business here? Is that what you're saying?
Yes. Yes, ma'am.
Okay, so tell me about the business. Where your hours of operation are going to be, where's parking going to be? Like, just kind of describe what you want to do.
I sent the plans to Ms. Gray. I don't know if are these it right here that I'm looking at?
Yeah, I have
believe
the latest
plans.
plans ahead.
These are the plans that I can't see that well. I need my glasses. I believe this is the plans. The hours of operation were from 11 a.m. to 8 p.m. That's what we were gonna do there. We was gonna sell pizza, wings, salads, and stuff like that.
Okay, and what days?
I want to add, like I say, I didn't know anything about I didn't know nothing about that. It wasn't zone commercial. I always thought it was zone commercial. And then we got into COVID. And so the property's just been sitting there, and it's kind of like an eyesore. I keep it maintenance. A lot of times people dump trash on there, and I got to get mattresses and stuff like that. I got to, constantly clean up because people, they just use it as a dump site a lot of times. So I want to really try to do something with the building to get it from being an eyesore in a neighborhood like that.
Mm-hmm. So kind of tell us what you want to do with the parking lot here.
Oh, the parking lot is all in the plans. It would be paved out, the awnings, new window. It was a total rehab. So any violations that was on the property before would have been addressed, because everything that has to do with the property has to be new plumbing, new electrical, I did put a new roof on there already because it was leaking. But everything else will have to send them to the councilwoman. I don't know if
Well,
these are it.
yeah,
Yes.
well, what you sent to the councilwoman doesn't make it to the Board of Zoning Appeals, and we still,
Oh, okay.
because you're appealing for a variance, we need to know what you're doing regardless of who else you talk to.
Oh, okay.
So, all right, so, and how many spaces are you planning to have here?
One.
One parking space?
Oh, no, parking.
Yeah.
That wouldn't work. I think it was, I believe it was 10.
Okay, and you plan
Yeah, I
on
believe it was.
paving and draining all
Yes.
that around there? Okay,
Paving it, total rehab.
okay, all right, good.
I talked to Nyman Construction. They came out, reviewed it, gave me an estimate and everything. And their whole thing was just like, if it can get converted over back to commercial, just give me a call, because they was ready to go. But everything was this was a hold up. This was backing it up.
We got you. Okay, all right, Xavier.
Okay, yeah. So it looks like you got 13 parking spaces on this plan with the ADA right there in the front, right off of Kingsman. I think the main issues was like the landscaping. I think he wasn't reaching the minimum.
It looks like he has some in there though.
Yeah. And I mean it is. See, it looks like okay, about yeah. I mean, the main concern really is just making sure that experience just kind of walking through is more pleasant. Let's see
Yeah,
what we got here.
it's kind of hard looking out there now.
Yeah, no, yeah. I think abutting that residential, more the residential district. But no, yeah. I mean, let me see here. I mean, if there's any possibility to kind of increase that landscaping, um, that would be kind of beneficial. But
Yes.
Yeah, Mr. Hill, where you have like your landscaping now, are you open to just adding a little bit more in there?
Yes, I know in the back it was a lot of grass back there. Like I said, I usually get that cut and clean once a month to get, keep the trash and everything from being, because it's such an eyesore. I had to boarded the windows up, boarded the windows up and everything. But it's just, in the neighborhood, it just looked kind of bad as it is right now. But as far as everything that we were going to do to the property, once completed, it'll be I believe it'll be a positive look to the forest on the neighborhood and everything.
Okay, so we're just talking about, like the perimeter of your property, like before it hits the sidewalk.
Landscaping.
Yeah, just a little extra
Yeah.
landscaping in there, green it up a little bit more.
Yeah, that's no problem. That's
Okay.
no problem.
All right. Ms. Wilson, is Councilwoman Gray here, or will you have to speak for her?
I'll have to speak.
Okay, go ahead.
Everything looks okay to me. I mean, if Councilwoman approved it, she said she wanted to have this other meeting today, but unfortunately she isn't here. But she says she does approve it, and she would love to go forward with it.
Okay, thank you.
Okay.
All right, board, any questions? Hearing none, I entertain a
Sorry,
motion.
Madam Chair, I am not used to using a mouse instead of my my keypad, my touchpad. I'm on a different laptop. So anyway, little delay there. To Mr. Hill, if I may, sir, what we often do is we ask, this is a really good looking site plan that you submitted.
Yes.
It looks really nice. But what we typically often ask people to do as an attachment to these is to give us what we call a cut sheet of what your fencing is you're going to use, and also some pictures, a cut sheet of the plants that you're going to use. Would you be able to supply us with those?
Who would I get those from? Would I go back to the architect and get those?
You can go to the probably your architect would be able to compile those pretty quickly and easily for you. Yeah. And that would give your whole project a cohesive look and would sort of I would make me anyway, as a board member, feel more comfortable about the landscaping that you plan to install.
Okay, so moving forward, what do I need to do?
Just have have your architect supply whatever the landscaping that you plan to do in those areas where you have landscaping. Just kind of show what kind of plants and or bushes that you're going to use there.
Okay, no problem.
And then the fence. So we make sure the fence meets the visibility standard.
Okay.
Okay.
So I take care of this. I can get with Mr. Harlan to take care of this. So in the process of this, so who do we got to come back to a meeting, or do I just submit it?
No, you can have your architect just send those to our secretary, Ms. Kukla, and we'll move forward. Okay.
Yeah, actually, the fence isn't one of the variances, Ms. Faye. So we'll be glad to have it, but we'll make that optional.
All right, that's fine.
So it's basically just the landscaping.
The landscaping, yeah.
Yeah.
Okay. He didn't include that in there? That wasn't in there?
Not what kind of landscape he's using. Like, you show him where it is, but we just need to see like what kind of bushes and flowers or whatever you're gonna put in there.
Okay.
And I think
that's no problem.
I think I'll add my main push for really like kind of increasing that landscape strip there. Like, maybe another 2 feet is really just because as these trees right here, these bigger circles, as those trees get bigger, I mean, you're gonna start to see some of those roots and kind of push up that sidewalk if it's only 4 feet and they're in the middle, so there's 2 feet on each side. And that's just a future concern is why I'm saying that.
Okay. So I take care of this. I can jump on this today, as soon as today, and get this to you guys. You said her name is Mrs. Kukla?
It's Kukla, our secretary. Yeah.
Okay,
Yeah, it's who you sent these plans to before, not the councilwoman, but the zoning office boarding. Oh my goodness.
Okay, zoning office. Okay, so after that, will we receive a letter giving us the clearance to go ahead?
Yeah,
We're gonna move forward. Sorry. Go ahead, Kelly.
Yeah, yeah. We have to vote on it now, but once it's voted on, you'll receive a letter about what happened today.
Oh, okay. Okay.
Okay.
Okay.
So
Well, thank you.
with that, we're gonna excuse me. I move on calendar number 22-232 that we go ahead and approve the variances pending the receipt of the planting schedule from Mr. Hill's architects.
Okay.
Second.
Board Member Holzer, I second.
Ms. Holzer with the second. Go ahead, call the roll.
Madam Chair, are we requesting that he add an additional 2 feet to the front setbacks? Sorry, the landscaping setback areas?
Yes.
Okay, so then the request would be a 5, or is that a 6? I'm sorry. Yes, that would be a 6 foot wide landscape strip along
on that one part.
Kinsman Road and East 125th Street.
Yes.
And the appellant is okay with that. Let's just get that for the record as well.
He said, okay, Mr. Hill say you need to agree.
I'm okay. Yes, I'm okay. I'm sorry.
Okay. Yeah.
Okay. Thank you, Madam Chair. Ms. Holzer?
Yes.
Ms. Brown?
Yes.
Ms. Bates?
Yes.
Ms. Britt?
Yes.
Calendar number 22-232 is granted conditionally. We will hold ratification until we receive the cut sheet showing the landscaping, or I guess a landscaping schedule would be fine, as well as a revised drawing showing the expanded landscape area. Once we receive that, the board will ratify it on the following Monday, and we will send the appellant a letter.
Thank you.
All right, thank you.
Thank you. You have a blessed day.
Thank you.
You as well. Good luck with your project.
All right. Thank you. I appreciate it so much, you guys.
Gonna look good.
All right.
We'll stop by
Bye-bye.
for pizza.
Yes, I'll send you some. I'll send you some. I promise.
No, don't send it. We'll just go there.
No.
I can send a salad.
No.
No,
Thank
nothing.
you.
You can't
luck,
send us
sir.
anything.
Okay. You guys have a blessed
But
day.
thanks
Thank
for
you
the
very
thought.
much. All right. Bye-bye.
Okay, old business.
I do have a lot of attachments after this. I just wanted to make sure you're.
We have those attachments, Xavier. Do not pull those up. Okay. Oh man. Okay. 2 through 7 and 9 without objection.
Without
Without
objection.
objection.
All right, and first we have which I'm not surprised at this, the Liz, the Hessler folks are taking us to court.
That is correct. Yes, they delivered it the Friday before last. So it's at the time, the clock is ticking. We have to get that in within 40 days to the Court of Common Pleas. And that's all that I really have for you right now for that.
That was
Okay.
expected.
That was expected. Okay, and then we have the number 1 on the calendar for 4100 Franklin. We have the resident, Mr. O'Leary, requesting that the board have an open hearing for the condition that we put on the variance. So as we circulated a couple of emails earlier, that we should vote up or down or whether we should conduct this extra hearing. I believe that our decision was made by granting the variance, and that we've never had anyone actually request this before, that we have a hearing on our condition on the variance that we already granted. So that's my position. If any other board members want to chime in about it, and I think because of the nature of this, that we should have a motion on whether we vote up and down on it.
Okay.
Madam Chair, if I could just say one thing for the record, I'm sorry to keep interrupting.
Go ahead.
But just one thing for the record, you've seen letters from Mr. O'Leary, the adjacent neighbor, as well as the attorney for the applicant. So we
Yes.
have both opinions.
Both sides, yes. I did read them. I'm pretty sure the board members read them over the weekend as well. And I just wanted to make sure that we had legal standing before we, could vote on this, and we were advised that he does, so that now we have to vote on it. So go ahead, Liz, if you want to add anything else.
One more thing for the record, you have received the security plan, correct? So you guys
Correct.
were able to look over that and are
Yes.
satisfied and don't see any changes or anything that you'd like. on this.
Ms. Brown does have a couple of questions about it that she sent me in emails that I will forward to you, Liz, so you can forward to the ministry, but I will not speak for her, but I don't think she wants that to hold up the process. But she had a couple things she wanted to see in it.
So, and also, Madam Chair, we're not ratifying that resolution today. So you'll have another, I can add those comments in for the record, and it'll be in the resolution for next week.
Okay, great.
So you want a motion?
Yes, please.
All right. I cannot read. Is it 23 dash? What's the number?
213, looks like.
23-213?
Yes.
Correct.
Okay. Thank you. So in reference to calendar number 22-213 regarding 4100 Franklin
I
Boulevard.
can send you the list. I have
Oh, yeah, please mute him. I think he's not aware he's still on. Okay.
Yeah. Okay.
ahead.
Which was a case that we heard and voted on, placed a condition on it, regarding the request for a rehearing or a public forum on this.
Hold on.
I think
Hold
today
on.
is.
Xavier, can you mute whoever else is not
That's
talking?
Mr. Hill, I
Mr.
think, right?
Butler.
Marissa, are you still there? I think he's still the host. He has to.
Oh,
Yes, I muted him. Thank you.
Thanks.
Okay. Okay, great.
okay. I'm sorry. Go
Um,
ahead, Alana.
Okay, so resuming my motion. So with regard to that, I move that we deny the request.
Okay, can I have a second, please?
Member Brown, I second.
Ms. Brown with the second. Go ahead, call the roll.
Ms. Holzer,
Yes.
Ms. Brown,
Yes.
Ms. Vig,
Yes.
Ms. Britt.
Yes.
Request for an additional hearing on calendar number 22-213 has been denied. The case will be ratified next Monday.
All right, and I will get you Ms. Brown's concerns, so make sure that those are addressed before we ratify.
Thank you. Will do.
Thank you.
Is
All
that
right,
everything?
that's it.
Oh.
All right, everyone have a good week.
Thank
Thank
you.
you.
You too.
Bye.
Bye.
Hi, everyone.
The public
Bye.
wasn't allowed to speak? I raised my hand.
No, Madam Chair, to the person speaking, no, the old business session is not open to testimony.
So, but I was told to either send an email or voice my concern in regards to the safety plan. So I logged on to the meeting with the link that I had, thinking that I could voice the concern with the safety plan, so it would be a record for appeal for litigation purposes. Because the safety plan is super generic and doesn't really encompass anything other than what they've already discussed, which is we'll provide cameras on our property. They state minimal, non-invasive, non-intrusive metal detection, but they don't even state what that is. They have no listing of qualifications for the training, nor what that training is and how long they've had it. Like, it's literally just putting on paper what they said. So I just wanted to make sure that I raised that objection, and I'm not trying to be disrespectful. I maybe got confused by being told I could either email to the WebEx or send an email. But I just, like, I have 7 kids. I didn't have the time this weekend with soccer and baseball and basketball to fire off an email. So I carved out time in my morning to log into this and listen to everybody's, fun presentation and, raise my hand. At least it would have been nice if the Madam Chairwoman or somebody who said, hey, in old business, you can put your hand down. We don't acknowledge you, because that to me was like a waste of 2 hours.
I am not sure who told you that you could testify. I'm not sure if anybody from the city would have said that. So you may have
got the
gotten it
link.
from a neighbor.
Okay. Well, I don't know. So that's none of that's entered into record. Can I still try to send you an email for those concerns today, since you've already voted to not listen any further to anything that's not what they've presented?
Right, you can definitely submit your comments to the file. But the board has decided not to take testimony on.
No, I know. I mean, that's fine. We've heard it. I mean, it's everybody's flying flags and bleeding hearts, but they haven't supplied any real legitimate basis for what they're saying. And everybody wants to do this great, wonderful thing without actually looking at the repercussions of the neighborhood as a whole, the residential part.
Yeah,
And it's
I
kind of-
understand.
it's kind of
We're
annoying.
not taking testimony. The hearing is over.
I know. So I appreciate your time. I did not mean to interrupt or keep you guys longer than the meeting ended. I thought that I'd have a chance to put that on record. But if you're saying I can still submit an email, like referencing what I just said to you guys, and just that I had been on the meeting, thought that I could submit testimony, but then was told that I couldn't. So I'm just to justify why I didn't send you something ahead of time. Is that okay?
You can send me the email. Yes.
Okay. And it goes right to you, Ms. Kukla?
Yes, correct.
Okay. I apologize again for the time for you 3 that actually entertained my bit of crazy. And I hope that you guys have a good rest of your day. And thank you very much. You guys have a
Thank you.
crazy hard job, and I wouldn't want to do it.
Thanks. You have a great day too.
You too. Thank you.